I got it.
Thank you. Thank you so much and good afternoon. Welcome to the House Committee on Innovation, Internet and Technology. It's Monday, March 29th. I'm Representative Deb Ruggiero, chair of the committee with my distinguished colleagues. I want to take a moment to just thank our technical staff here at the State House. You have no idea what they go through to put these committee hearings on air for all of us. So thank you to the men and women at Capitol Television. Our clerk today is Chris O'Brien. Thank you, clerk.
Thank you. No
Would you
problem.
please take the roll?
Surely. Chairwoman Ruggiero,
Present.
Vice Chair Handy, Representative Carson,
Present.
Representative Amore, Representative Chippendale,
Present.
Representative Cortfin,
Present.
Representative Craven, Chairman Craven, Representative Kennedy, Representative Lima.
Present.
All right, excellent. Representative Morales.
Present.
Okay. Representative Place.
Present.
Representative Messier. Representative Shanley. Representative Tansey.
Present.
Representative Tabone.
Present.
We have a quorum.
Well, thank you very much. This afternoon, ladies and gentlemen, we have a short presentation on the state's IT systems and cybersecurity plan for some of our state agencies from the Department of Information Technology. And then we have three bills that are before us this afternoon. H6042 by myself authorizes our Secretary of State and the Board of Elections to conduct an extensive cybersecurity assessment of our election systems and creates a cybersecurity review board. H5700 from Rep. Speakman is an act regarding student privacy rights and their digital information on school laptops and computers, and it limits access to student information by school officials, law enforcement, and third parties. And H6055 by Representative Barros creates consumer legislation to limit application payments for software software developers. May I have a motion to hold bills for further study?
Motion.
Thank you. And how about a second? Is there a second?
Second.
Thank you. The motion was made by Deputy Speaker Lima and seconded by Chairman Craven. Clerk, would you please take a vote on that?
Surely. Chairwoman Ruggiero,
Yes.
Vice Chair Handy, Vice Chair Carson, Representative Amore.
Yes, I'm sorry, I was muted.
Okay.
Yes.
Okay. Representative Chippendale,
Aye.
Representative Cortfin,
Yes.
Chairman Craven,
Yes.
Representative Kennedy, Representative Lima,
Yes.
Representative Messier, Representative Morales,
Yes.
Representative Place,
Nay.
Representative Shanley, Representative Tansey,
Yes.
and Representative Tabone.
Thank you very much. I just want to remind our audience that we hold bills for further study so we can hear the testimony that will be presented this afternoon. The public and the advocates weigh in, whether they're for or against. It's a constructive conversation. Testimony makes bills better, and I'd say close to 70% of our bills have what's known as a sub-A from these constructive conversations. They are amended, so we share, we listen, and we learn. And then when it's voted out of committee, we have a full debate on the House floor. So these bills are not dead. We just need your input. So at this point, we're going to turn to our invited guests from the Department of Information Technology to provide the overview that we had requested in our last meeting. BJ Kumar is the Chief Security Officer. Brian Tardiff has 30 years cybersecurity experience with the Rhode Island National Guard. He's the state's Chief Information Officer. And Alan Diaz has agency acquisition under his purview. So welcome, gentlemen. Thank you for joining the House Committee on Innovation, Internet, and Technology. The floor is yours.
Thank you. Thank you so much. So first off, thank you for the opportunity to be here today. BJ Kumar, I'm the state's Chief Information Officer and Chief Digital Officer. We also have Alan Diaz, who heads up agencies and enterprise applications. Alan has been with the state for more than 25 years. And of course, Brian Tardiff, our Chief Information Security Officer, who joined us from the National Guard 3 years ago and who has 20 plus years of cybersecurity experience. So with that, what I would like to do today is talk to you about the high level, what is ETSS, Enterprise Technology System Services, what are the agencies we support, the executive agencies, what our major applications are. Brian Tardiff will talk about the security posture for our applications and agencies and any other security questions you have. And then we can even answer some questions and answers as time permits. So with that, the ETSS department consists of Department of Information Technology and the Office of Library Services. And we support all the executive agencies. You all know what they are. I don't have to go through this slide in detail. But what we have done during my tenure here at the state is that we have actually completed the application inventory, and we have over 400 applications across these 14 agencies, and we have a list of all of those applications which has been shared with the legislature. It is also on our website, which is doit.ri.gov. I'm quickly going to go through the main applications we have. So when we talk about the main applications, these are actually the applications which fuel the agency and which are extremely important for government to function. Department of Administration, we have a finance, HR, and payroll system. This is on Oracle right now, and also we have a mishmash of different systems. The state published a strategic plan a year ago, and we had it in the budget proposal, and we're also looking to leverage COVID funds for modernizing this enterprise resource planning solution. So that is very much in the works, and we are hopeful that we can use the next COVID stimulus to start implementing this over several years. The budget system, the electronic procurement system, the enterprise content management system, and the legal case management system, all of these have been modernized during my past few years here in the state, and many of them have been completed. Some of them are close to completion. So from the Department of Administration perspective, all these systems are very secure, and Brian will talk about security and about all these applications, but we believe that these applications are very secure. The Department of Behavioral Healthcare, Developmental Disabilities, that, as you know, consists of the Illinois State Hospital. We do have several systems there which need to be modernized. The hospital is in dire needs of also EMR, electronic medical record system, which again we are putting in the request for the COVID stimulus fund, and that is something which would really help the agency. Department of Business Regulations, we have electronic permitting for municipalities. This has been rolled out to most of the municipalities. It is a relatively new system. It is cutting-edge technology. That is in good shape. We have several other systems in DBR, including the medical marijuana seed-to-sale tracking system, which needs to be modernized. DCYF, the primary application is RICHES, the Child Welfare Information System. Need to modernize. Again, that has been in the budget request, and we will be looking to secure funding to modernize that. Department of Corrections, we have a new probation and parole case management system, which is ready to go live. We are looking to go live in early July, and that is a modern system. INFAX is the Inmate Facility Tracking System. That needs to be modernized. And wherever I'm not calling it out, all these systems are actually secure, and Brian will talk about how that is being carried out. Ensuring cybersecurity best practices, how that is being carried out. Department of Environmental Management, again, they raise revenue through permits, but we have been looking for funds to modernize these applications. Many of these applications are on ancient technology. They are stable, but many of them could be end of support, both in terms of resourcing as well as system stability down the road. This is actually also one of our requests for the COVID stimulus funding for modernization. Department of Health, as you know, the state has been a trailblazer in contact tracing, contact testing. We have a Crush COVID RI application, and also we have vaccination systems. Most of these systems are new. The vaccination system is PrepMod, which is a older system. We are providing good service to the people of Rhode Island, and as you know, this is a combination of Salesforce, our homegrown application, which is available on the iPhone and Android systems, and of course, PrepMod vaccination system as well. All the other systems are stable, but again, we are looking to modernize these systems. There is also a new vital record system, which is actually being implemented. Department of Human Services, you all are very familiar with UHIP. That project has been green for over a year, and we are actually in the process of picking the maintenance and support vendor for the future as the current contract expires. That project is also very stable, and again, that is technology which now is several years old, but it is a stable system as of now. Department of Labor and Training, and again, this is an agency where we did have some fraud on unemployment, as we had in several other states or all the other states in the United States. This department, we have all the systems I mentioned here: employer taxation, temporary disability, unemployment insurance, or the UI system, and workers' compensation. There is a need to modernize all these systems. Unemployment insurance, again, we have moved hardware to a relatively new platform, so it is stable, but functionality could be better. So that is something which the state needs to do in the next several years. As far as fraud is concerned, Brian will talk about it when we cover the security piece of it for the agency. Department of Revenue, which includes taxation and DMV. We have a modern STAR system, and for taxation, that is again on-premise. We are looking to move it to the cloud. Other than that, the system is highly functional. DMV, again, we know that this went live several years ago, and that is completely stable. I would say a relatively modern system. License renewal, registration renewal are on ri.gov, and those are modern systems as well. Department of Transportation, again, we have critical request systems and PMP systems, and again, we continue to enhance them, but they are stable and secure. And last but not least, the EOHHS, or the Executive Office of Health and Human Services. We have the Health Information Exchange and Quality Reporting System, but we also have the MMIS system, which we need to modernize. And again, we are in the process of soliciting proposals so that we can modernize the system in the next several years. So these are the major applications. So what Brian is going to do now is he's going to quickly talk about our security posture for these applications. He will also highlight the Department of Labor and Training, just because there was some fraud activity there. And together, the three of us will answer any questions you have on applications for these agencies or the security posture. Over to you, Brian.
BJ, excuse me, before we go to Brian, some people do have some questions, if you don't mind. Whip Chippendale, did you want to ask a question?
Yes, please. Thank you, Madam Chair. Thank you, Mr. Kumar, for your presentation today. One thing perked my ears up when you were speaking. You said we're going to modernize bridges. I sat here in 2016 almost in this exact spot when we learned that bridges had literally driven off a bridge. And to my knowledge, that contract with Deloitte has not been satisfactorily completed yet. So imagine my curiosity when I learned we're going to be spending money to modernize something that hasn't even been completed. Can you please elaborate on why would we be doing that?
Absolutely. So first off, the Department of Human Services, that is where I have listed RI bridges or UHIP. We are not looking, sorry? Sorry, did you say something?
No, sir. The floor is yours.
Okay, I'm sorry. So we are not looking to modernize RI bridges. So I'm not saying that we are going to modernize RI bridges. The Deloitte contract expires this year, In the past year, we have gone through an RFP for maintenance and support of RI bridges going forward as well. That is what is in process, and this year we will be doing a new contract. So that is what I said. So we are not looking to modernize RI bridges at this point. The system is stable from a functionality and technical perspective.
Thank you very much.
Thank you.
Thank you.
And Clerk, would you please recognize Representative Kennedy and Messier, and do you both want to be not only present, but affirmative in holding bills for further study? Thank you, Clerk. Representative Place.
Thank you, Chairwoman. You had mentioned BHDDH and the electronic medical record system. I know they've been trying to get that for quite some time, and I know that the Veterans Home has it already. And I was just wondering if you could speak to why, up to this point, we haven't moved forward with the electronic medical records at Eleanor Slater when we already have it in a state agency down at the Veterans Home.
Alan, do you have more information on the VA system?
Yeah, BJ, from what I understand, the Veterans Home is more of a nursing home type based software, whereas BHDDH, the software they're looking for is more of a hospital management type software. So there was some incompatibilities there.
And your understanding is BHDDH is still requesting the hospital level software, and that's going to be in the current proposal this year?
It is going to be in the current proposal. So, as you know, currently all the executive agencies, including the DOA, we are working on proposals for COVID relief funding. And the electronic medical record system is a system we are going to be requesting for funding. So this has been a requirement for us for the past few years, and the primary reason we have not moved forward is finances.
Thank you, sir.
Thank you.
Thank you, BJ. And Brian, now off to you for the cybersecurity portion of this. Thank you.
Thank you, Chairwoman. Thank you, BJ. So BJ provided a brief snapshot of the over 400 applications that we have enterprise-wide across the agencies that we support. And we look at the enterprise and the applications from a holistic view and deploy a defense in depth strategy, looking at the people, process, and technology required for an effective cybersecurity program. Over the past 3 years, we've implemented a robust cybersecurity awareness training program for our end users that are accessing these applications across the enterprise. We also execute phishing campaigns monthly as a training opportunity for what we view as the most consistent threat in our environment, which is phishing and ransomware attacks. Process-wise, we have established a firm cybersecurity framework in alignment with the NIST cybersecurity framework. All of the enterprise policies and procedures reflect that cybersecurity framework. We implement security controls based off of the categorization of the systems in our environment, whether they be sensitive, contain sensitive data, or they're public data. Vendor accountability is critical with our applications and the vendors that manage our IT systems. We monitor their activities and hold them accountable to adhere to the state security requirements. Vulnerability scanning and patching of systems occurs on a weekly basis, so we have weekly knowledge of any new vulnerabilities within the environment. We also execute penetration tests of existing applications to mitigate any design flaws or potential vulnerabilities within those applications. We have exercised our cyber incident response plans and shared those with municipalities and other agencies across the organization. And we receive regular cyber threat intelligence from multiple partners, including the state police, the FBI, the NSISAC, the Rhode Island National Guard, and vendor partners such as IBM. This past year has proven challenging with remote work. We've looked to extend our security footprint beyond the connected enterprise through leveraging cloud-based security applications to monitor the remote workforce so that we can proactively mitigate any vulnerabilities or threats that are identified on those remote workstations. We have anti-phishing and anti-malware technologies deployed throughout the enterprise, and we are actively engaged in lifecycle planning of not only the enterprise applications, but the infrastructure and hardware that hosts those applications. Lastly, we are implementing and have implemented encryption at rest and in transit for our critical systems that house sensitive data on both the remote workstations and in the server environment. Briefly, I'll touch on DLT and the fraud work that has occurred there. As you all know, and BJ alluded to, this was a nationwide fraud case where bad actors leveraged previously stolen data, which was not stolen from the state systems. We have no indicators of compromise on state systems. This was data that was available on the dark web, and they leveraged the opportunity that, unfortunately, that the pandemic with unemployment presented to use that stolen data to file fraudulent claims. We've leveraged vendor partners and AI to track that activity and the signatures that were created by those bad actors to proactively prevent those fraudulent claims from occurring. That has not been obviously 100% successful, but through our defense in depth strategy, we have been able to prevent a large number of fraudulent claims from being filed. With that, I think we are moving on to our Q&A.
I have a question, Chairwoman.
Thank you, Lauren. Rep Carson, sorry about that. Go ahead, and I'll hold off on my question.
Okay, I want to say thank you to you both for making this presentation, and I've met with BJ multiple times about the status of our systems, but I still have more questions. And so one of the more significant experiences that the members of the House particularly had with our technology system was what happened with, the systems the system that we have with the healthcare program, and that Representative Chippendale just spoke of. And that was a large program. Thousands of Rhode Islanders were in that program. It was a major transition to a new piece of software. So I guess I would like to ask for a little more information, and there's really no hurry on it. But what I'd like to ask for is when you itemize these programs that need modernizing, my question is, how many Rhode Islanders are in those programs? Like, how big are they? Are they going to affect 200,000 Rhode Islanders or 20,000 Rhode Islanders? Because that will indicate several different things. It will indicate costs, so we can be prepared for them, and it will tell us the magnitude of the transition of the software transition. So at some point in time, for all the ones that you said modernize, if you could just put the impact on Rhode Island in terms of general numbers, and approximately when you think they need to be modernized. That would be very helpful.
That's a great recommendation, Rep. And I would also ask, BJ, if you could not only put that together, but also send this PowerPoint presentation to the clerk so it all can be distributed to the committee members. And I think a timeline as to when these software programs need to be modernized is important. Great question, Rep. Thank you. I have a quick question for you, Brian. There are a number of state agencies, though, that are not under your purview, correct? I don't even think legislative data systems is under your purview. We have our own system, correct?
That's correct.
As well as the Attorney General and the Secretary of State. So if there's no uniformity across the state amongst all of these agencies, how do we solve a cybersecurity problem should something occur, or do you not see this as a threat?
No, I do see that as a threat. We do work to collaborate with our partners in other agencies to share their best practices. And we also, through our membership in the Joint Cyber Task Force, have a robust incident response capability that will not only support state agencies, but municipalities if needed.
Any other questions? Whip Chippendale, thank you.
Thank you, Madam Chair. And this certainly could be answered by either BJ or Brian. In the introduction, BJ had mentioned that we were going to be modernizing with an ERP system. Is that true? First question is mostly yes or no. Is that true that we'll be using an ERP type system throughout all of those agencies that you referenced? That would be,
You're muted, BJ.
Sorry about that. So the state has not had a ERP strategy for a while, and we have been written up for several years. 2 years ago, we did a strategic plan. The state worked with the vendor to come up with a strategic plan, which is also available on our website, including a video, and we did share it with the legislature, with some of the committees. We have a strategic plan today, which we hope to start implementing this year. We have to go to RFP to select a commercial off-the-shelf software provider. So we are going to pick an ERP software which exists, which is going to be customized and configured for Rhode Island. And we will be implementing that so that all agencies, all executive agencies, all the quasi-agencies, and even the universities can leverage. That is the plan.
outstanding. So that ERP software, whichever we settle on, will sort of be the umbrella for, so Bridges will be under that. It'll be fed and maintained through the enterprise resource planning software that you purchased, correct?
So the ERP software is actually going to be pervasive across all the agencies. That is for finance, HR, payroll, time and attendance, and several competencies we do not have. Now, Bridges is actually the health and human services part of it, which will talk to this system. So ERP is actually different from the health and human services program, but again, they will be talking to each other as required.
Okay, thank you.
Representative
Thank you.
Place.
Thank you. I don't know who's best to answer the question, but to what degree has the state looked at blockchain technology and its potential use in the near term and future?
Great question, thank you. So the state has actually done a proof of concept, and which has been successful. This was completed end of last year, early this year, and we were waiting for the new administration to take over and then discuss next steps. So yes, we have validated that proof of concept, and with your advice, recommendation, and support, we would be happy to move forward working with the administration on that.
Could you elaborate on the test that you did or the proof of concept?
Yes, so Liz Tanner from the Department of Business Regulations has been a big champion of blockchain, as you all probably know. So what we did is, out of the Department of Business Regulations, a concept which can be used and put in production with approval from the legislature, the administration, is the concept of identity for businesses or for individuals. So that is something which we can validate. Like, for example, and again, I don't want to speak out of turn, but just to be creative, and as a technologist, with your approval is when we move forward. But what I would like to say is that we could have an identity for businesses, so that if you have something validated with the Secretary of State, you don't have to go through paper forms and digital forms to validate things again with each and every agency. Once you validate your identity, you could actually leverage that across multiple agencies.
And Rep Place, I've actually had a number of conversations with Director Tanner on the blockchain concept, and I'm going to invite her to come in and actually share that information with this committee, because I think that's very important. It's the future, and it's really an important stronghold for this state. So thank you for that explanation, BJ. Any other questions from the committee? And let me just check the screen for our committee members who are remote. I don't think I see any. Is there? No. Okay. I thought I saw someone with a question. I just want to make sure.
Chairwoman,
Yes.
it's Rep Kennedy.
Yes.
Question, you talked very briefly about what took place with the Department of Labor and Training, and we know they had a mammoth task that they had to try to get as much money out to our constituents as possible that were unemployed, that needed the federal relief funds. That being the case, we also know with the amount of fraud that took place, we're talking about millions upon millions of dollars. And I know that DLT has been working with the state police and others to try to get some of this money back. But the question is there something that we could do in the future within our particular computer system here in Rhode Island state government to try to mitigate something like this in the future, recognizing that much of what was done was because of information that was stolen or secured via, the dark web. What could we do to ensure that this doesn't happen again, so that we don't have another potential mass fraud event take place?
It's a great question, Rep. Brian or BJ, would one of you like to answer the question?
BJ, I'll take that one. So we have, through the course of the year, and as you stated, DLT's rapid response to the demand, kind of on the fly made security enhancements and corrections to this fraud situation. We were able to identify on the network perimeter the bad actors' IPs and actively block those IPs, working with our vendor partners for leveraging artificial intelligence to further identify those indicators that those filing the claims were fraudulent. Moving forward, as we look to modernize the UI applications, we're working with vendors to develop and further enhance that defense in depth strategy that will harden the application to the point where we can, through technology, harden the systems as much as possible. There will be process refinements that will be required, and of course user training and public training as far as what indicators they should be looking for fraud. But I'm comfortable that we're on the right path, and certainly as we look for enhancements to that system, technology will be put in place to further prevent that fraud from occurring.
Well, that, I think it is important that we get to that particular stage. It's interesting, our local newspaper, the Westerly Sun, ran an article about one of the local police officers in my district who received a letter when he showed up at the post office informing him that his unemployment compensation claim had been approved. Of course, he hadn't filed for one. No less than 2 weeks later, I received one of those, and I knew I hadn't applied for unemployment compensation. So, I think the state DLT has done a great job. Their fraud division has been involved with this. The state police have done a great job, but I noticed in the last couple of weeks when I've been getting particularly emails from constituents who have applied for unemployment compensation, they've had it started and then it's stopped because of potential fraud issues. And these people are saying, we paid into the system for 40 years. What's going on here? So, the good thing is DLT can get those restarted again. But I hope we can harden the system to a point where, it becomes a seamless process going forward. And at the same time, it protects this, because when we're talking about the amount of money that has gone out of the state for these particular claims, it's just very concerning that potentially there's somebody living on an island somewhere that is sitting back very fat and happy knowing that all this money has been deposited into their account.
Thank you, Representative. It's an excellent point, Rep. Kennedy, and we've all received those letters. A number of us have become victims of this fraud. And I do want to commend DLT. I know when I've asked them to respond on behalf of my constituents, they have just been incredibly fast because many of our constituents, as you know, need these unemployment checks. So what we would like, BJ and Brian, again, if you could put together a synopsis of the software that you've outlined here with this presentation, how many Rhode Islanders are affected, what your timeline might be for it. We may bring you back with further questions, but I'd like the committee to at least review that data. But this was a wonderful overview, and I thank you. I thank you very, very much. Thank you. Now we will move on.
Thank you for the opportunity.
Thank you for what you're doing for our state. Keep us safe. So at this point, I'd like to move on to the bills that are before us. And I would like to, first of all, apologize to the committee, because I'd like to move my bill forward first, because I put it in on behalf of the Secretary of State. She is on WebEx and she has another meeting that she needs to get to. So if you will indulge me, H6042 is our first bill, which I've introduced on behalf of Secretary of State Gorbea. And the bill before you has 4 components. First, it establishes an election system cybersecurity review board. It requires the Secretary to conduct a cybersecurity assessment of the state's election systems and facilities. Third, it requires annual cybersecurity training and best practices for all of our local election officials. And finally, the bill creates a cybersecurity incident response group, which includes the state police, Rhode Island National Guard, the Division of IT, whom you just heard from, as well as Rhode Island EMA. And this establishes a communications protocol in the event of a cybersecurity breach on the state or the local level. So that's a synopsis of the bill. It's kind of the thing I think the state and local infrastructure really is what this committee is looking for. So with that, and here to further explain why we need it, Secretary of Gorbea, welcome to the House Committee on Innovation, Internet, and Technology. The floor is yours.
Thank you, Chairman Ruggiero and members of the committee, for the opportunity to speak with you tonight on this critical topic of cybersecurity and the maintenance and protection of information for Rhode Islanders. Also, thank you, Madam Chair, for introducing this legislation on behalf of my office. Now, as you all know, as Secretary of State, one of my core missions is to ensure that elections are fair, accurate, and secure. That mission has evolved dramatically in just the past 6 months. 6 years. It seems like 6 months. 6 years with regards to cybersecurity and how that has come to the forefront. With the support of the General Assembly, I have worked to modernize our elections infrastructure and invest in cyber training for staff at all levels of government. And while I'm very proud of the work that we've done to protect the integrity of every vote, there is sadly no finish line with cybersecurity. It is one path that we just need to continue to build and improve on. So we need to continuously assess and invest in our systems and our people. Just as important, we must apply this successful approach to other areas of government. As public servants, we are charged with maintaining and protecting information for Rhode Islanders. And I know that the discussion from DeWitt and the committee has clearly brought that up. This is critical as cyber threats are continuously evolving and placing new pressures on the public sector. In the past few years alone, we've seen several local communities successfully targeted by ransomware, which held important public data hostage at the expense of taxpayer money. These breaches can also provide hackers with new avenues into other government systems, so while it may seem like an isolated incident, it really, in the world of cybersecurity and systems, there is no isolated system here in our state. And so, state and municipal governments have to remain vigilant, adaptable, and prepared so that we can mitigate risk at every level. This is not a question of just prevention. It's a question of being prepared. So when something does happen, we're already on it and we're prepared, and we don't have to suffer any kind of ransomware or even worse, deletion of data. So that's why I've worked to introduce House Bill 6042. Prior to the 2016 election, cybersecurity was frankly not in the forefront of election officials. However, the past several years have shown the critical importance of investing in cybersecurity and being prepared for cyber attacks. Along these lines, I really believe that it's important that our laws reflect changing responsibilities and communication channels necessary to protect state and local governments from a cyber incident. What we're doing here, while to the benefit of the election systems, for the security of the election system, really has broader benefits in our state's public sector. House Bill 6042 looks to codify in statute some of the initiatives that we've instituted over the past several years to enhance the security and integrity of our elections. This is basically things that we had already started to evolve on their own organically because we needed to on the fly. We wanted to make sure that we codify so that everybody is clear as to what needs to happen when and if there is a breach. I won't go over the major components because I know that the chairwoman did a very nice job of summarizing it. But But, given the trends nationally and the incidents that we've seen here in our own backyard, a comprehensive cybersecurity approach is really necessary to protect the integrity and ensure public confidence in our elections. We have to make sure that Rhode Island is ready to face cybersecurity threats of the future. And this is a big undertaking, and it's going to require coordination and communication from many across all levels of government.
Thank you.
And this legislation does just that. It codifies that kind of communication and gets us ready to confront what's basically a constant enemy. Thank you so much for the opportunity to testify today on this critical issue. And I ask for your support of House Bill 6042 so that we can protect the integrity of and promote confidence in our elections.
Thank you, Madam Secretary. Members of the committee, any questions? I'm just looking for our committee members at home. Madam Secretary, I just have a question, and we didn't really talk about this when I put the bill in, but the cybersecurity analysis, the third party, and the training of our local board of canvassers, is that a financial impact that's going to be within your current budget, or are we going to see you coming before House Finance, on which I also serve, looking for a little bit more money in your budget?
So up to now, we have been able to use federal funds. So for example, the initial review that we're looking to do would be done with federal funding. And that's a great use of those funds. In the future, yeah, we'll have to absorb that because, again, this is not a one-time deal. But for right now, what we're looking to do, we can do with our federal funds.
Thank you. Any other questions? There is no one else. Thank you, Madam Secretary. Else listed to testify. We do have written support from Michael Steinmetz. He's the former state cybersecurity officer and Homeland Security advisor for Rhode Island. The ACLU is supportive, but they would like it amended. They think any cybersecurity breach also should be disclosed to the public as well as other agencies, and I would concur with that amendment. With that, we have no other testimony, and that would conclude our testimony on that bill. I also want to remind our viewers at home and members that we have written testimony on the General Assembly website. If you just go to the home page and you click on the documents and then the name of the committee, in this case it's the Innovation, Internet and Technology Committee, and you can actually see all of the written testimony that's been submitted for or against. Our next bill is House Bill 5700 by Representative Speakman. And this bill is in regards to student privacy rights and their digital information on school laptops and computers. It also limits access to student information by school officials, law enforcement, and third parties. Representative Speakman, there you are. I see you. The floor is yours. Thank you for joining us.
Here I am. Thank you, Chairwoman and colleagues on the committee. Can you hear me okay? Okay, thank you. So this bill is already outdated because of the changes in the relationship between students and their technology and their school system. And you'll hear some testimony on that, and you've seen some written testimony on that. So we do need to do some work on this. But the purpose of this bill, as the chairwoman said, is to make sure that students' privacy rights are preserved when they take technology home from school. And the legislation, as you see it, proposes an opt-in agreement in which the specifics of the relationship between the student, the technology, and the school district would be clearly laid out, the terms and the conditions of the relationship. What access does the school have to information that the student is using when the laptop is at home? What requirements can the district impose on use of the technology? And what kinds of data can be shared as the student gathers information and does his or her work? What kinds of information can be shared by the school district with other parties? So the bill, which comes to us from the ACLU, proposes the establishment of policies. I think all of the school districts and the other advocates who submitted testimony agree that there do need to be policies to safeguard the students' privacy when they do take home technology from school, but that this bill needs to adjust to the new reality that virtually all students have technology at home with them. And for many of them, that's the only way that they're communicating with their district at this point. So with that, I will turn it back to the chairwoman. I think there are several experts who are going to testify on the bill.
Thank you.
Thank you for your attention.
Thank you, Representative Speakman. We appreciate that. And yes, now we have a number of people who would like to testify. I just want to remind our guests, you have 2 to 3 minutes to testify. And when you think about it, if you're in your car, that is 4 to 5 30-second radio commercials without changing the station. So please, let's be tight and bright. Our first guest is Tim Ryan, the Rhode Island Superintendent Association. He is opposed, but he's going to testify. Hi, Tim Ryan. How are you today?
Good afternoon, Chair Ruggiero, and members of the Innovation, Internet, and Technology Committee. My name is Tim Ryan, and I represent the Rhode Island School Superintendents Association. I'd like to thank Rep. Speakman and the ACLU for proposing this legislation. I think it's very, very important, particularly in this day and age. We, our Superintendent Association, recognize the need for all districts to have clear policies about Internet use, the responsibilities of the student, the parent, and the school. We also want to make sure that we're ensuring that we have privacy for students. We don't want apps used that data from students could be used for private purposes. We want to make sure that doesn't happen. And at the same time, we want to protect the taxpayer investment that we've made in Chromebooks for our kids. Chromebooks and computer devices have become integral to our educational program, and we've seen that particularly during the pandemic when we had to resort to distance learning. And it really is very, very important that we recognize this. Superintendents, we have been working with the Rhode Island school technology educators, the ACLU, our attorney, Ben Scungio, and we're very confident. Right now, the bill, I think, needs a little work. It's a little bit dated when it looks at how we use technology in school. And I think, again, I've communicated closely with Hannah Stern from the ACLU, and I'm very confident that we will come up with a common ground, making sure that everybody has a clear policy. We may wish to have the state develop a model policy for us, and making sure that we're protecting our kids. But this is a very important issue, and we are committed to working with all parties to make sure this happens. And I greatly appreciate the opportunity to testify before the committee today.
Well, thank you, Mr. Ryan. We greatly appreciate your input. Yes, Rep. Place, do you have a question?
Yeah, Mr. Ryan, I'm still not clear. You said you were opposed to the legislation?
Yes,
sir.
Could you
explain, could you explain why?
Only as written. I'm sorry.
Could you explain why? Because I didn't really hear anything in that says why. Well,
one of the things that the current legislation would allow, and again, it's a little bit dated, for example, that if this concept would be that parents could opt out of technology and using the Chromebooks. And we think that that would be a mistake because during the pandemic, we absolutely rely on those Chromebooks. So we want to limit, we're not saying that parents don't have access, shouldn't have control and say, but we want to make it a little, we don't want to have a carte blanche opt-out, for example. There are other aspects of the law that right now don't recognize how integrated technology is. And I think there'll be some speakers later from the Technology Association that will make reference to that. So we're in favor with the concept and the intent of the bill. We just think, and I think you'll hear from the ACLU, that it's our intent to work together to submit a substitute. And that I'm very confident we'll be able to support, sir.
Okay, does that answer your questions? Great, thank you.
Madam Chair, I have my hand up. I don't know if you can see it.
Sorry, you've got to really wave it higher. Thank you. Rep. Lima, the floor is yours.
Actually, it's funny that the last witness just said that because my comment was directed to Rep. Speakman, the sponsor of the bill, and I just wanted to say I really like the fact that she put it would be an opt-in as opposed to a lot of things we see you have to opt out of. So I really like the opt-in. I think that's a great concept. It's proactive on the parent's part.
Wonderful. Thank you for that.
Madam Chair, I have a question also.
Representative Carson. Yes, thank you.
Thank you. I absolutely support this idea 1,000%, Representative Speakman, and I thank you for doing it. But it seems as though much of the bill is between the privacy as it relates between the student and the academic institution. is there anything between the student and the software vendor?
I'm sorry.
Yeah. Go ahead.
Again, I think the technology folks would be better equipped to answer that. But I think right now we have very specific agreements with what the kids are using the computers for. We don't expect them to be just wide open with access, and that's where some of the agreements, the policy issues come in. We want to be very clear. Newport, for example, has a good policy that we want to take a close look at and have other communities in the state have similar policies. It lays out very clearly what the student responsibility is, what the parent responsibility is, and what the school responsibility is, and exactly what is shared and with whom. Right now, every district in the state doesn't have such a policy, and one of the parts of this bill that we like so much is that it would mandate that everybody has a model policy that would be enforced. I'm not an expert on this, Rep. Carson, so that's my answer at this point.
Yeah, I have a couple other questions. Is there any way you could get that Newport policy for us so we could take a look at it? Because
Sure.
I'd like to see it just generally. I think other members of the committee might like to see that. Yeah, I have some concerns about the data that the vendor has. That's what I'm also very interested in because, vendors, we're going to hear, we hear all the time about the fact that our data is being saved by these vendors, and these are kids. I know that the programs are very restricted. I know that the students can only work within a certain scope of applications, but still there is work there. There is some private data there. So my concern is about the vendors. I also had some concerns about the storage of the data. And I don't know who can answer this, but how long the data. So I'm a student and I'm working on this program, and it's like September and October and November. How long? Where is it stored, and how long is it stored? I'm of the opinion that some of that should be either downloaded to the student and not kept on a server someplace, or it should be wiped clean at the end of a school year. So I do have my questions more revolve around the relationship with the vendor. And I'd like to see anything that we have on that from Newport, for example, so that maybe that can help us to determine the best way to go with this bill. I would appreciate that. Thank you.
Okay, thank you, Rep.
Absolutely.
Carson.
And a subsequent speaker from the Technology Association, educators, will be able to address that more specifically. But one of the issues you raised, Rep. Carson, is very, very important, and that a teacher might come across an app to say, hey, this is great. It would be great for my kids to study economics using this app. We need to vet every app that we use. We need to have assurances, guarantees that student privacy will not be used for any other purpose. That's why we're very specific about how we use these devices, where the information goes. But the speaker from the technology educators will be able to address that in a more technical manner. But I will certainly get the Newport policy, and that's an example. It's not, again, the ACLU friends gave that as an example. I think we want to make sure that that's up to snuff and even better than it is, and use that as a model around the state.
Now, Tim, are you speaking about the IT person who's Jeremy Taylor?
Yes, Jeremy Taylor will be
he's going to be testifying
to
shortly, so why don't we move on? And thank you for your testimony, Tim. And now we have Hannah Stern, who would like to testify. She's from the ACLU of Rhode Island. If we could please get Hannah on the phone, clerk. Thank you, Tim. Hannah, of course, is in support since Rep. Speakman mentioned the bill was put in on their behalf. Ms. Stern, welcome, and you're on. 3 minutes. Thank you.
Hello. Hi. Thank you, Madam Chair and members of the committee, for your time this afternoon. My name is Hannah Stern, speaking on behalf of the ACLU of Rhode Island in very strong support of this legislation. And we'd really like to thank Representative Speakman for her introduction in support of this bill. I think that computer privacy is really, especially student computer privacy, is really an issue that has only grown in importance within the last year. Since the pandemic started and in the months since, we've heard from so many parents at our organization who have contacted us with extremely valid and legitimate concerns about what's happening to their child's data and their child's information and who has access to it, both in the schools and in the tech companies that supply the programming or the technological tools for virtual and distance learning, which, as we know, is how a lot of education has taken place over the past year. But unfortunately, what we've also really had to tell all of them is that there are no statutory requirements which provide privacy to students in a comprehensive way, and there are no laws which can be really pointed to say, this is how my students' privacy and my privacy is being protected. So last year, we actually published a report on these policies in every district in Rhode Island, the policies relating to school-owned computers. And we discovered that, I'll just give you one really, really concerning statistic that we found from there, but we found that 67% of school districts in Rhode Island actually allow themselves access to the camera and microphone of a school-owned device at any time. So there's nothing in the policies that prohibit the school from accessing the camera or microphone on a school-owned device. Of course, this is really concerning at any time, but especially with the perspective of the pandemic and the amount of schooling which has to take place and still does take place in the private home, it's the protections from possible incidents like this and providing students and families a reasonable expectation of privacy that we think really does need to be codified in state law, just so that students and their families aren't protected or not protected dependent just on where they happen to go to school and the patchwork of protections that is in place right now district to district. So as noted, we are currently working on an amended version of this bill with full personnel just to ensure that the language is actually accurate to the technology being used. But the concept and intent of protecting student privacy will remain at the forefront. This is really an issue that I think has yet to be tackled nationally or even in other states. So passage of a bill that provides strong and comprehensive protections is not only necessary for our students, and it's something that parents are asking for and are contacting us about, but it would really set an incredible precedent for ensuring privacy for students and their families. We think it's just really sorely needed. So thank you for your time. I'd be more than happy to take any questions that you may have about this.
Thank you very much, Ms. Stern, for your testimony. Any members have a question? Ms. Stern, I just have a quick question. Under the penalty section, the very end of the bill, is this something you're also amending? I'm not clear who you're suing. Is it the Rhode Island Department of Education, the school district, or local municipalities?
You know what? Sorry, let me scroll down really quick. Hang on. Sorry, my computer is very slow.
It does say on page
That's a
2,
good
line
question.
6,
Yeah, that was-
award injunctive relief against any school or agent of any educational institution.
Okay.
Yeah, that's a really good question. That's something that we would probably
You'd have
need to clarify
look
in
at that.
amendments, but we are doing a comprehensive amended version. So
Thank you.
I'll make
No,
a note of that.
I
Thank
know
you.
we had talked about an amendment. No, okay. I thought Rep. Place had a question. He changed his mind. Thank you very much, Hannah, for your testimony. Next, we have Jeremy Taylor from the Exit West Greenwich Regional School District. He is opposed. And do we have Jeremy on the line? Jeremy, are you there?
I am.
Wonderful. Welcome to the House Committee on Innovation, Internet, and Technology. The floor is yours.
Thank you. Chairwoman Ruggiero, other distinguished members of the committee, thank you for the opportunity to testify today about H5700. My name is Jeremy Taylor. I'm the tech director at Exit West Greenwich, and I'm on the board at RISD. I implore the committee to re-examine the issues and draw different conclusions for the target of this legislation. Devices are provided to students in order for them to complete their schoolwork. These are not personal devices. I don't believe that school districts spying on students is an extensive problem and does not warrant this type of legislative response. As written, this bill could completely derail one-to-one initiatives statewide. We need to teach our students how to responsibly and effectively use technology. To not do so would do a disservice to them and to their communities. I hear concerns about student Google accounts, but when I explain to parents that K-12 accounts are not the same as the regular consumer accounts they use and have additional protections, those concerns are usually alleviated. Allowing parents to opt out might require different curriculum for those students, different computing devices that are costly to procure and manage, and would be a significant burden to school districts. We all agree that Rhode Island school districts should have clear, concise policies around student devices. I would point to the success of Chapter 1621.6, Internet Filtering in Schools, that required adoption of a model policy developed by RIDE and would encourage legislation along those same lines. Those policies might cover restricting remote access to student devices and the ways that information like precise location data can be used, but school districts still need the ability to locate devices that are lost or stolen, or to help parents find missing children. I would support legislation that compelled software vendors to sign a student data protection agreement. Many school districts have joined the Rhode Island Student Privacy Alliance, mine included, with the goal of ensuring that all of our software vendors protect our students' data by signing a data protection agreement. I would even support restrictions on the use of technologies that monitor student device activity outside the school day, so long as the responsibility for doing so is also eliminated. I presented these arguments in much more detail in my written testimony, and I thank you for your time and consideration. I'm happy to answer any questions you might have.
Thank you, Jeremy. And yes, you did provide very extensive written testimony. Committee members, Representative Tanzi has a question.
Thank you, Madam Chairman. Are you supportive of the 60-something% of schools that allow for access to microphones and camera?
I think, so when I saw that statistic, the first time the ACLU did a review of school district policies, I was working at Westerly Public Schools, and I made sure that any further policies that we passed included that we did not have access to it. I would ask the ACLU, do they not mention it at all, or does it restrict them from, does it say that they can? Because it hadn't even occurred to me that that would be an issue when I wrote our policy in Westerly. And I made sure to include it in Exeter West Greenwich's policy that we do not have access to the microphone and camera unless it's initiated by the student for an educational purpose.
Okay, yeah, it seems, if it is in the homes the way they are now and there's access to the entire home environment, I think that these are things that many districts like yourself previously hadn't thought about and need to be addressed. I think that this bill, while needing a little bit more updating, is imperative. Mm-hmm. I'm interested also in the comment that you made that you're willing to not be concerned with the things that go on after the school hours, as long as you're also not responsible for the use of the computers beyond school hours. That was just something that kind of stuck out. So you're saying liability?
I'm sorry, I didn't mean to cut you off.
No, please.
A lot of school districts, mine does not, but some school districts use some technologies that monitor student activity outside the school day. They have it goes through emails and looks for anything that might flag as a student might be looking at self-harm or committing an act of violence, and schools are taking the position that they should do anything possible to try and prevent that type of activity. But I know that the ACLU has expressed concern that we're doing that type of monitoring. So we don't mind. My school district doesn't do that. We take the position that we know our students very well. It's a small school district, and the teachers aren't supportive of that type of monitoring. But in bigger school districts, they do use that type of monitoring. And if the legislature doesn't want us to use it, that's fine. But we want to make sure that we're not going to get called to account for not doing it if it's not something that we're allowed to do. You know what I mean?
Yes.
All right. Thank you, Madam Chair.
You're welcome. Very good question, Representative Tanzi. And Representative Place has a question.
Sir, you stated that your school district has a policy in place that doesn't allow access to the cameras and the microphones. How do you enforce that policy?
We don't have the capability to turn on a student's camera or microphone remotely. The student can turn it on when they're in a Google chat or when they're in a remote support session, but we don't use software that would let us turn that on remotely and monitor it.
All right, so it's not just the policy, you've actually changed your software to prevent it from taking place.
We do not support using that type of software. Some school districts do, we don't.
Okay, good. Any other questions from members of the committee? I'm now looking at the screen. I don't see anyone raising their hands. Thank you very much, Mr. Taylor, for your testimony. It really helps. We appreciate it.
Thank you very much. Have a good day.
You too. And now we have our last person to testify on this bill is Randall Rose, who is in support. Could we get Randall Rose on the phone, please? Has he left the building? We lost Randall. Okay. Well, that concludes the portion of our verbal testimony. Our written testimony, as you know, comes from Mr. Tim Ryan, looking for the amendment. Jeremy Taylor, as you just heard, has some concerns, and the ACLU is in support. That concludes the hearing on Rep. Speakman's Bill H. 5700. Our last bill is from Representative Barros. This bill protects developers of software applications concerning use and purchase payments. Thank you, Rep. I see you on WebEx, so please tell us all about your legislation.
Thank you, Madam Chairman and members of the committee. As the chairwoman said, Bill 6055 would provide protection to developers and software application concerning the use and payment of their purchases. This bill is basically about big tech and the power they control, they have over us, the power and control they have over us overall. The issue here is that the big tech, they're not going away, and the sooner that we address them, and the better we would all be served. This bill, again, is about the big tech and their ability to monopolize the system and charge us whatever they feel it's fair. They raise prices for us consumers and drive up competition. This is a bill, this bill is a common sense bill and a consumer protection piece of legislation. That would put the brakes on big tech's monopolistic practices and give Rhode Island more choices while at the same time lowering costs for our state's innovators. People, you will hear folks after me who certainly have a lot more capability in terms of what it this, for me, is this bill is very simple. It's very, very simple, and it's very transparent. What you will hear from them, however, is that it's very complicated, but if on its face, what I'm proposing is rather simple. The only complicated part in this, and the complexity that I see, is that they have a monopoly on the system, and the complexity is greed and total disdain for competition in the marketplace. So that's the reason why I actually put this bill in. And as I said, there are other folks who are going to testify who have more information on the technical side of this whole thing. And with that, Madam Chair, I conclude my testimony.
Thank you, Rep. Any questions? Yes, Whip Chip has a question for the sponsor.
Thank you, Madam Chair, and thank you, Rep. Barros. I just have one question. Typically, when we introduce a piece of legislation, it is in response to something that occurred or is occurring, or sometimes we're asked to put it in to resolve an issue. What was the origin of this legislation? What compelled you to put this in?
Well, I mean, I've had conversation with some folks who talk about the ability to get on Apple or Google Pay, and those were issues that folks were saying that unless you use those platforms, you were not able to do any you could not conduct the transaction. And not only that, I think they were saying that they were charging exorbitant amounts of fees for those other folks to use their platform. So that's the genesis of there.
Okay, thank you very much.
Okay. Do any other committee members have a question for our colleague, Rep. Barros? Seeing none, I will say we have 7 guests who wish to speak for and against this bill. So we will allow them all 2 to 3 minutes to testify. And let's begin with Mr. Carl Szabo of NetChoice. He is opposed. He's not answering. Okay, we can try him and we'll go on to the next person. David Edmondson of TechNet is also opposed. Could we get David on the line, please? Mr. Edmondson. Good afternoon, Mr. Edmondson from TechNet. Welcome to House Committee on Innovation, Internet, and Technology. The floor is yours.
Thank you, Chairwoman and members. My name is David Edmondson. I am TechNet's Vice President for State Policy and Government Relations. TechNet is the national bipartisan network of technology executives that promotes the growth of the innovation economy. I am here testifying in opposition to H 6055. In short, the bill would undermine the entire app delivery and development ecosystem while placing Rhode Island consumer data and privacy at serious risk. App stores are global digital marketplaces that promote innovation and drive economic opportunity for small companies in Rhode Island and across the globe. Leading app stores invest vast resources in an infrastructure to support regular malware scanning, prevent restricted content like pornography, and manage safe and secure payment activities. H 6055 undercuts those ongoing investments and places the state in the position of intervening in existing business-to-business contracts to advantage one set of companies to the detriment of others. The end result is that Rhode Island consumers would be made more vulnerable to cybersecurity threats. For example, subsection B1's restriction on the exclusive modes of distribution seems to mandate sideloading, which is the practice of downloading unvetted applications to a device. And while not all platforms require exclusivity in distribution, removing it for those that do would undermine the platform's ability to provide a secure environment for its developers and users. So all applications on leading app stores are carefully vetted to eliminate security risks, which prevents the overwhelming majority of malicious apps from reaching Rhode Island users. By contrast, subsection B1 seems to force App Store providers to allow access to apps that are unavailable in the official app stores for any number of reasons, including privacy and security risks. So once these malicious apps are installed, they expose users and their broader connected networks to very real cybersecurity threats. So, for example, malware introduced through an unvetted app could allow hackers access to a consumer's sensitive data, photos, and even the device's camera or microphone. I'll just close by noting that the technology industry heavily invests in securing consumers' privacy and security. The success of these efforts hinges on the ability to build and maintain trust with consumers, and building platforms that ensure a secure environment is of paramount importance. H 6055 would completely undermine this and opened up Rhode Islanders to new privacy and cybersecurity risks. Therefore, we must respectfully oppose the bill.
Okay, thank you very much for your testimony. And we have a question from Representative Chippendale, and then we'll go to some members who also may have another question. Thank you, Rep.
Thank you, Madam Chair, and thank you, David. David, I'm going to attempt to make an analogy, and I'd like you to tell me if I'm all wet or if I made a good analogy. So, we create highways in the U.S., in our state. We have side roads, we have freeways, we have off-ramps, we have on-ramps, we have traffic circles, we have traffic lights, signs, police officers who keep them safe. The crews go out there and sand them, and we as citizens get to use those highways. We don't have to maintain them, et cetera, per se, by ourselves. That's done by the state. However, as users, we pay fees to register our car, to inspect our car, et cetera, and therefore we have the ability to access these complex highway systems, these interstate systems. I see this similarly. I see that Google and Apple and some of the others have created these highways, and folks are using them to develop applications. Is that a fair analogy, in your opinion?
Thank you, Representative. And yes, I do think it is quite analogous to this situation. The service fees that are discussed pay for the data storage of the developers' apps, the internet infrastructure to deliver the apps, privacy protection to ensure that those apps are safe, training for developers, ongoing support for developers, and access to literally billions of users immediately. So it's like the world's biggest store shelf. So I think that is a very apt analogy.
Thank you. And there's a tremendous value-added element to what they're offering. Correct me if I'm wrong. If you do know the answer to this question, I am to understand that all 50 states are currently in federal court attempting to litigate this very issue. Is that true?
I do not. I'm probably not the best person
Okay.
to answer that question. Yeah, unfortunately, I appreciate it though.
Not a problem. Thank you for being honest on that, and thank you for the dialogue. Thank you, Madam Chair.
Yes, sir.
Thank you. Thank you, Whip Chip. Is anybody, other colleagues from the committee who have a question? Seeing none, thank you so much, Mr. Edmondson, for your testimony.
Madam Chair, I had raised my hand on the computer. I don't know if you were able to see it.
Oh, no, you have to really, put your hand up. I was looking and didn't see your hand up. I apologize. Deputy Speaker Lima with a question. Thank you.
Hi, David. My concern is if these apps are not going to Google and Apple and they're going to another platform, could they have viruses on them since they're not as secure?
David? They tell me that David hung up. So
He hung up?
But it's okay. We have other witnesses who probably could answer those questions, Rep. Thank you.
Thank you.
Okay. So now we will go to David Hansen from Base Camp, who is in support of this legislation. Is David on the phone? Okay. So this is David Hansen, again from Base Camp, who is in support of the legislation. Nope. That sounds like a disconnect. Our clerk is having some trouble getting people on the line, so we'll just be patient. Okay. So Jonathan Cantor from the Cantor Law Group, who is in support of this legislation, is on the line, I think. And if he is, Mr. Cantor, that's the jingle. Good afternoon, Mr. Cantor. Welcome to the committee. You have the floor.
Very good. Thank you very much for having me today. My name is Jonathan Cantor, and I'm here on behalf of the Coalition for App Fairness and the Match Group in support of House Bill 6055. The Coalition for App Fairness is a group that represents developers of all sizes, and I want to thank the committee for considering this important issue. Despite what you might hear today, the issue at hand here is actually quite simple and straightforward, and I'd like to specifically address the requirement in this bill that would allow choice with respect to payment system. So first, I want to start by encouraging you to ask yourself a question. How many people do you know who use something other than an Apple or an Android phone? Personally, I cannot think of a single one, and I suspect you cannot either. And that is monopoly power, and that is why we need House Bill 6055. Second, it is well within the rights to address the states to address the abuses of monopoly power. State antitrust laws have existed for over a century, and it is well within the constitutional rights of the sovereign state to enact its own antitrust and anti-monopoly laws, especially for critical areas of the economy like mobile commerce. Indeed, as the committee studies this bill, I urge it to clarify even further that the bill only applies to instances when a developer is based in Rhode Island or a user is based in Rhode Island. This clarification would allow 6055 to make Rhode Island a key destination for app developers, benefiting the local economy and creating jobs. Third, House Bill 6055 addresses obvious harms. The mobile platforms, Apple and Google, charge 15 to 30% for any digital transaction because they have no competition to keep prices in check. Commercial payment systems costs range by comparison from 1.3 to 3.4%. For example, PayPal is 2.9. Therefore, the rates in these mobile app stores are egregious by comparison. 15% is between 4 and 11 times the pro-competitive rate. 30% is between 9 and 23 times the competitive rate. The only thing standing in the way of these market rates are monopoly contracts that prohibit and conditions that prohibit the use of competing payment systems. This is the problem that the bill addresses, I believe, successfully. Fourth, the proposed legislation is constitutional. This legislation does not actually impose any burden on developers. In fact, if a developer wants to continue using Apple or Google for its IAP in-app payments, nothing in this bill would stand in the way of developer making that choice. Finally, pending legislation in California does not affect the state's right to preserve its citizens. The fact of the matter is these App Store issues are not being, there is a pending case in the Northern District of California, but that is the only major case going on right now. And litigation with Apple has been stuck in the courts for 10 years and will likely continue for another 10. Apple has already appealed, in fact, one of these cases all the way up to the Supreme Court on a procedural issue and loss. And there's harm happening right now, and the state cannot afford to wait another decade. If anything, this legislation will clarify this important issue and the need for costly and burdensome legislation. And so in conclusion, as I mentioned at the outset, this is not complicated. Tortured analogies or folksy stories are not necessarily understand the issue at hand. The same goes for the scare tactics about privacy and security. All that is misdirection. This is just about money and about a requirement that developers use payment systems from Apple and Google exclusively. Developers just want the ability to pay competitive rates for accepting payments from consumers. If Rhode Island decides to protect its citizens from these abusive terms, two of the world's most powerful monopolies will no longer be able to extract as much from the companies, and users will have no other choice. The monopolists would hate, and we others would have other choice. The monopolists would hate that, of course. You'll hear today, in fact, from some dominant companies and their trade groups that they sponsor, and I urge you to ask them if they take money from Apple or Google. Finally, objections from dominant companies certainly doesn't make something bad policy. If anything, it suggests that you're on the right track. Thank you for your time and attention today, and I look forward to answering your questions.
Thank you, Mr. Cantor, for your testimony. I appreciate your economic development argument that maybe app developers will start coming to Rhode Island. But since these are national platforms, how does a state regulate commerce outside its borders? And have any other states passed similar legislation? And is any of it in litigation?
So no other state to date has passed this legislation, although a number of other states are considering it. I will add that the state antitrust laws, which affect commerce coming in and out of their states, has existed for, like I mentioned, over a century and is well within the rights of a state to ensure that it's protecting consumers and commerce and citizens in their states. And so in this instance, it's no different than Rhode Island's current existing antitrust, the difference being that it provides opportunities for competition to occur. And it is one of the reasons why I do recommend that as you study the bill, clarifying that it applies either when a developer, meaning not the platform, but the developer, an app developer, is located in Rhode Island, or the consumer consuming the app is located in Rhode Island.
Thank you very much. I believe Representative Lima, did you have a question that you wanted to ask? You're muted.
So, okay, I have an Apple computer, an Apple Watch, an Apple phone because of the security that Apple provides. I feel comfortable as far as spyware, malware. So, if I'm getting these apps on another platform, where is that security I'm going to be getting? And could those apps then put a virus on my devices?
Right. So the piece of the legislation, it's a great question, thank you. The piece of legislation that I'm addressing specifically relates to the payment system. So it's not about what app you can download or not download and whether you even have to go through the store. The portion of the legislation that I'm here to address is whether somebody who owns their own app is able to accept payments through their own payment system or PayPal or Stripe or directly through a MasterCard, instead of having to go through the platform's payment system, which charges a significant multiple of the market rate. In addition, there are other restrictions that these payment systems impose, and I think you should think about whether they're good for Rhode Islanders. One is that if it's cheaper to get something on the web, these platforms and Apple's terms and conditions specifically say you can't even inform a user that a lower price is available somewhere else. You can't put a link in the app. You can't even put a mention in the app that it might be cheaper to go somewhere else. That's a pretty significant restriction that results in consumers paying more and app developers having to pay more for their payment system.
Thank you very much. Does that answer your question, Rep? Okay. Rep Chippendale, you have a question?
No, not necessarily a question per se. I am going to go on ahead and make another tortured analogy. Only this one hopefully will be a little bit easier to understand. Right now, if you need to engage in a personal injury issue, you hire an attorney. Now, you certainly have every right in the world to represent yourself pro se. It's right in the Constitution. But we all hire attorneys for our actions. And those attorneys take 33% of what the return is, typically. Sometimes it's more. I'm sure that there is some where it's less. But in Rhode Island, 33% is what an attorney gets. And why? Because they went to law school. They know the system. They can argue to my benefit. It makes sense for me to hire them and pay them 33%, which is much more than this. So that is an analogy that certainly every Rhode Islander can understand. You get what you pay for. But I want to be a little bit more Rhode Island centric on the actual nuts and bolts of this, because right now, as we sit here, there are only 2 companies in the state of Rhode Island who are subject to the maximum 30%. There's 2. There's 439 app developers in Rhode Island, and there are 379 of them. 86% are operating commission-free. If you make less than $1 million on either one of these platforms, you can negotiate a much lower, in fact, up to 15% commission rather than the 30%. You can't advertise that you sell it on the side through their site for obvious reasons. You can't take advantage of all of the benefits they give you and then try to side hustle it. It'd be like paying somebody to advertise a product for you on a commission basis and then selling it out of the trunk of your car. I don't find anything wrong with this legislation, which is protecting what these companies built. And frankly, without what these companies built, all of these millionaires we've seen pop up through apps would never have had the chance, because they would have had to gone through all the development of the distribution, the monetization, the safety, all of that. But no, it's a heck of a lot easier to pay somebody else to do that. We do things on commission all the time. It does not make it a monopoly. Everyone is available and free to go and develop their own apps and market their own apps on the internet. Nothing is prohibiting anybody from doing that. But if you want the safety and security, and frankly the audience, because this is really what they bring you, then you hire someone who charges you a commission. Simple as that. Thank you very much.
Thank you.
Yeah, thank you for that question. May I offer a response?
That was not a question, Mr. Cantor. It was actually a comment. But we do have a question from Representative Tansey. Rep Tansey, the floor is yours. Thank you.
Thank you, Madam Chair. And I think this will give you an opportunity, Jonathan, to respond. You mentioned PayPal as a comparison, and I don't see the comparison with PayPal being accurate. To me, PayPal is like the credit card provider at the store where people want to sell their merchandise. So it's not unusual for someone who's wholesaling their merchandise to a name brand store to sell it on their behalf, like a Macy's or a Nordstrom, to get a percentage of what it's sold for. And if they have such a great product, then they strike out on their own and they create their own name brand and they make it the Gap, and then those two compete. So I don't get the analogy. I don't think it's as simple as you put forward, and I don't think that PayPal is a good analogy, charging 3%, because to me that's what normal credit card fees are, whereas this is really more of a retail opportunity where they're wholesaling their product for somebody else to market, hire the employees to manage the platform or the store, or however you want to describe it. But, I don't see that as an apt description.
Yeah, so I think that, thank you for that question. I appreciate it. It's very helpful to illuminate some important points here. First, this is not a department store, right? These are apps that developers build, and consumers are consuming them inside the app. And so the IAP is an in-app purchase. And what essentially the platforms are saying is you have to use our in-app purchase system to process payments exclusively. And as a result of that, you have to pay 30%. But if there were competition for that component, you would spend a lot, developers would pay a lot less. They would pay substantially less. And this is not really, just to go back to the earlier question, it's not about like attorneys. I mean, in fact, if I'm an attorney and if someone doesn't like my rates, they can go to another attorney. That's competition. And you talked about representing pro se earlier. That's what the developers want to do. They want to represent themselves pro se by offering a direct payment in their app, but they can't. I mean, this is.
But you're using the Apple platform, so you've told us what you're not. You're not a lawyer. You're not a store, a department store. I still don't understand what you are. Then provide us with an analogy?
Yes, it's a platform product like Microsoft. This was at issue in U.S. versus Microsoft, an important antitrust case from earlier in the century. And what the court found there was that they said just because it's legal to own a baseball bat doesn't mean it's legal to hit somebody over the head with a baseball bat. If you have a monopoly platform that's supposed to connect users and developers, it does not mean that you can impose whatever restriction you want that limits competition. That harms the competitive process. A company like Apple charges $99 to all developers for distribution. And so why is it that a company like Facebook that makes billions of dollars in ad revenue pays $99 a year, but if I want to sell a subscription to a yoga service, I have to pay 30% to Apple? It's because I can't use another payment system. And those kinds of restrictions in platform products are a problem. That's why we're having so many conversations about big tech. And it's not just big tech generally, it's big tech platforms, because these platforms basically induce everybody to participate on those platforms by offering the opportunity to connect folks. And Apple makes a lot of money from selling their phone. They make a lot of money from their $99 a year. They make a lot of money from selling in-app ads. But they also want to make a lot of money from selling the payment service. And if there were competition in those payment services, then folks would pay a lot less. And that's a competitive problem that the competition and antitrust laws, can and should be able to address.
Mr. Cantor,
but your two options that your option that you just put forward, I think it was a yoga studio or yoga classes or something along those lines. Like there's free on YouTube where people can get that, and then people can also stream it from a website on their computer. So I don't see the market isn't defined exclusively by apps. There are alternate modes by which people can access these products. So if someone chooses to associate themselves with an Apple or a Google, that is the market, I suppose, and that's that's what the app developer chooses not to participate in.
Rep. Tansey, thank you very much. That's an excellent point. Mr. Cantor, thank you for your testimony. And obviously we have other people who want to testify, those who are opposed and those who do support this. It's a great conversation. Let's go to, do we have Morgan Reed on the phone? David also supports this. Okay, if David's on the phone, again, 2 minutes, because we have 3 other people who want to speak, and it's nice to kind of alternate it between those who support and those who oppose, so we hear different arguments. David Hansen with Basecamp, who supports this. Are you there? That's the 3rd try for him. Okay. Chris, why don't we go to Mark Buse from Match Group? Is he on the line? It's not usually this difficult.
Hello?
Hello, Mark?
This is David Heinmer Hansen.
Okay, David, you have 2 minutes. Please share your thoughts on the legislation. Thank you.
Sure. Chair, members of the committee, my name is David Heinrich Hansen. I'm a developer and the co-owner of the Chicago-based software company Basecamp. We make several apps that are distributed on Google's and Apple's app stores. I'm testifying in favor of H6065. Apple and Google's monopoly on the distribution of mobile software is extorting app producers and consumers around the world. Rhode Island has a historic chance to be the first to say, not in our state, to assert its obligation to do what's best for Rhode Island, its businesses, and its residents. The market is not going to fix this problem by itself. Apple and Google's dominance is now so complete that they have absolute power to dictate all terms of the deal. App makers can either submit or face being put out of business. Apple and Google exploit this fear of being put out of business to say, oh, this is just a battle between billion-dollar companies. Yes, mostly in public it is, because you need to be worth near $1 billion to take them on. When we looked into suing Apple for threatening and acting to kill our new email business, Hey.com, we were told we had a great case, but it would take up to a decade to resolve with all the appeals and easily cost us $25 to $40 million along the way. All developers like me are asking is that we be treated the same as Facebook or Uber on these app stores, two businesses that do not pay 30% of their revenues to be on the stores, despite processing billions either directly or through apps. Why do Facebook or Uber get to skip this tax? Because Apple and Google said so. There's no deeper logic here than who do we think we can successfully shake down for revenue? Our company, Basecamp, already pays $99 a year for a developer license to distribute software on Apple's App Store. Apple makes hundreds of millions from developers with this fee. Don't tell me a company worth north of $2 trillion that grew revenues 20% last quarter and returned $30 billion to shareholders during that time need to shake down a minority of developers on top of that to make ends meet. As David Cicilline, Rhode Island's own chairman of the Congressional House Antitrust Subcommittee, has said, this is highway robbery. Apple operates a toll booth on the only road to the distribution of mobile software for the dominant iPhone platform. And this doesn't just hurt app developers, but consumers as well. When Apple tried to shake down our company for the 30% cut of revenues, they explicitly encouraged us to simply pass on the cost to consumers. And that's exactly what other developers have done. Rhode Island has the power to make the first meaningful step toward addressing the problem with big tech in America by protecting businesses and consumers against these app store abuses. Pass H6065 and you will instantly turn Rhode Island into one of the most desirable places on earth to start a new software company or move an existing one. I'm happy to answer any questions.
Thank you very much, Mr. Buse. Any questions?
Madam Chair?
Yep, I see you, Rep Lima. Go ahead, thank you.
Okay, because I did have my technological hand raised. I was waving. I guess it must be hard to see.
It's hard to see. There is no technological hand, only your physical hand. So thank you for raising it.
No, I'm hitting the one on the computer. Isn't that what I'm supposed to hit?
It is, but it's so small. What I really see is your hand. So I thank you for raising it.
Okay. Because I wanted to start my question with the last caller, but this is fine. So the last caller had said basically they have a monopoly. There's no other platform. But I'm looking at Google's competitive advantage is it provides an incredible fast search and tools to support the general search engine. And there are competing search engines, Bing or Yahoo, but to develop their infrastructure to match Apple or Google, they'd have to spend a ton of money. I'm going to use the Chippendale model and use why I'm having a problem with this. I spent a couple of $1 million and I opened up a big restaurant, and my restaurant is known for serving the best steaks in the state. I invest all that money, I reach out, I do my advertisement, I do all my due diligence, I'm bringing in a lot of customers. Now I get a couple of small vendors who spend a couple of $1,000s on a cot. And they're going to be selling their product right next to my restaurant. They want to take advantage of, I have this customer clientele, but they're not investing as much as I invested. So to me, it seems that Apple and Google invested all this money to reach out to have a great clientele. But what I'm hearing is, well, they have a massive clientele, but I don't want to pay the 30% to have access to that greater clientele. And having access to those numbers is going to make me more money. So that's why I'd have to pay that more money. That's why I'd want to be on that platform, so that I could make more money and have access to all their clientele. And to me, that sounds like the American business model.
Thank you, Rep. Lima. Thank you. Any other questions from committee members? I don't see any hands raised. Thank you very much, Mr. Cantor. Now we are going to hear from Morgan Reed from the App Association. They are opposed to this legislation. Morgan Reed, are you there?
I am. Can you hear me?
We certainly can. Thank you for joining us, and please provide your testimony in the next 2 to 3 minutes. Thank you.
No problem. Good afternoon, and to the chair and members of the committee. My name is Morgan Reed, and I'm the president of the App Association. We are the leading trade group representing small software and connected device companies in the app economy. Our industry employs almost 1,600 people in Rhode Island and includes a member company, Blackburn Labs, based in Providence. We have serious concerns with HB 6055. We believe the bill would undermine the services we purchase from software platforms and reintroduce grave risks to consumers and, frankly, the wallets of parents throughout Rhode Island. Right now, smaller companies derive 3 overarching benefits from the 15% we pay platforms. Number 1, immediate access to the global market. I've heard a lot of you talk about the fact that it's more than just a payment system. This is a huge one. It gives us access to this huge global market. Number 2, offloads overhead. And this is not just payments. It includes everything from managing updates, dealing with international tax law, advertising reviews, placement, and more. Most importantly, number 3, consumer trust. HB 6055, with its sideloading provision, undermines this trust. Specifically, the bill opens the door to massive abuse by some companies. And I don't want to be accused of scaremongering, so let me tell you exactly what happened back in 2011. Parents in Rhode Island and across the country discovered that children were running up bills of $1,400 in a single month without mom or dad knowing, buying Smurf berries. Smurf berries are an in-game digital good similar to Fortnite skins. Parents were rightfully angry and they demanded changes. State AGs pressured the platforms, which took action and reimbursed the parents, and afterwards the platforms made changes to their software in terms of service to prevent a similar problem. Unfortunately, HB 6055 undoes all of the protections that consumers demanded and puts us back in a world where a Capcom or an Epic Games can run parental credit cards via whatever payment mechanism it wants, and there's nothing platforms can do if this opening is abused. If this happens again, the trust that my members, the small guys, depend on will be broken. The ability for the platform to say no to some companies removes virtually all barriers between bad actors and consumers' money and data. In fact, we are asking platforms to do more, not less, to stop bad actors and scam apps. If Rhode Island says platforms are not allowed to remove fraudulent apps or fraudulent payment processors, Rhode Island is giving them direct access to consumer bank accounts. Finally, I think it's pretty telling the last bill discussed had witnesses and members saying we don't want wide open access and asking questions about vendors, which were all great, and the way they store data and maintain data handling. HB 6055 makes it harder for platforms to play a role in accomplishing the outcome that we just discussed around student privacy. It moves us in the wrong direction, and I think it's worth opposing this measure until it has some more forethought.
Thank you, Mr. Reed. I appreciate your analogy with the Smurf berries and, kids running up expenses for their parents. What security, though? Let's say you come out with an app that's the greatest new, best video game or app for a kid. What security does a parent have that when it's downloaded, it doesn't have malware? What protections are you providing?
Great question. So this is the mechanism that the platforms really play right now. Platforms sit in a space where I have to submit my app to the platform, and that app is then reviewed by the platform. It's checked, they curate it, they look at if my code makes unexpected calls or does unexpected things. In fact, probably the most frustrating thing for my members is often going through the review process with Apple or Google because they nitpick and they look at everything. And so one of the areas that they do a lot of is checking for malware. Especially what you see is if your app is making unexpected calls or unexpected actions. So that's exactly the role the platforms play. They are kind of the first gatekeeper that lets me in the door. And the reality is I can put an app out via HTML5 that's available from a web app if I don't want to go through that curation process. But basically, the difference is this. If you think about it right now, most of you go to an app store and you download an app, and you probably don't ask yourself a ton of questions about what's going on the privacy and security side because you're depending on the platforms to do that gatekeeper role. You treat it differently when you download something randomly off the web. My concern is I don't want the platform environment to have that same lack of trust that has been grown through these app stores that gives people much more comfort and, frankly, helps me my members turn interest into a customer. And that's what we're interested in.
Thank you, Mr. Reed. Any questions from the committee? I don't see anyone raising their hands or asking, but thank you very much, Mr. Reed. That was very enlightening testimony, and we appreciate it. Next, we have Mark Buse from the Match Group. Mark is in support of this legislation. Do we have Mark on the line? He's not there?
Hello? Yeah.
Oh, yeah. Hi. Mark, welcome. Welcome to the House Committee on Innovation, Internet, and Technology. You have the floor for a couple of minutes. Please tell us your position on the bill.
Yeah. Oh, yeah. Hi. Mark, welcome.
Well, Mark, you've got to turn down turn down your volume because there's reverb. Thank you.
Thank you. Madam Chair and members of the committee, thank you for your leadership and for considering this important and groundbreaking legislation, which Match Group, a developer offering a portfolio of online dating brands, strongly supports. Thank you for your leadership and for considering this important and groundbreaking.
Okay. Did you, sir, you have to turn down your volume because we are getting reverb and echo. Could you please turn down your volume on your television? Thanks.
Yes. Nearly all of us today use a smartphone. Our smartphone is often the first thing we see when we wake up and the last thing we see when we go to bed. We use it to read the news, to bank, to place orders, and to have food delivered. All of these things require apps, and those apps are hosted almost exclusively by two operating systems, Apple's iOS and Google's Android, who together have monopoly power over the app distribution market on mobile phones. Apple and Google use their App Store monopoly to function as the gatekeeper to all mobile devices, while collecting data and details about our lives that very few people fully grasp. This isn't just my opinion. Recently, as part of the U.S. House of Representatives Antitrust Subcommittee investigation into digital marketplaces, Chairman Cicilline said, and I quote, "This hearing has made one fact clear to me. These companies, Apple, Google, Amazon, and Facebook, as they exist today, have monopoly power." In fact, Chairman Cicilline also acknowledged the fact that Apple and Google also use their monopoly to force approximately 15% of all apps to pay a 30% tax on every transaction, calling it highway robbery. For Match, these App Store fees are one of our largest and fastest growing expenses. Our businesses, along with millions of other app-based businesses, cannot simply shift our users to the web or to other devices because there is no real alternative to smartphones. The reality is, if your business doesn't have an app, you might as well not exist. We live in the mobile world now. We all know it, and so does Apple and Google. In fact, just 6 months ago, Apple's own CEO, Tim Cook, emphasized the critical and novel nature of apps and app stores when he testified before Congress saying, "We treat every developer the same. We have open rules. It's a rigorous process. Because we care about privacy and quality, we do look at every app before it goes on. We apply these rules equally to everyone," he said. The facts show a different story. Apple has erected a glossy veneer around a capricious decision to force 16% of the apps in the App Store to use its in-app payment processor, which comes along with an oppressive 30% tax. Let me address the specious arguments you're hearing from Apple and Google. It's for safety, they say. Not true. Brands like Tinder, which we operate, is expressly for individuals over the age of 18 only. Apple knows the age of every customer, and yet Apple will allow a 14-year-old, your 14-year-old, to download our app. is for security of payments, they say. Yet they allow all sorts of known bots, fraudsters, scam artists onto our platforms. Just last week, Apple was sued yet again over App Store scammers. And over the weekend, Apple released an emergency update to patch to address a serious vulnerability found in iOS, iPadOS, and watchOS. I raise this example not to be critical of Apple. All developers have to remedy vulnerabilities or problems with their apps, but to call out the hypocrisy of claiming some additional security is needed for a select 16% of apps and not all apps.
Thank you.
It's for privacy, they say. Well, how does Apple and Google forcing vast swaths of data make anything more private?
Thank you, Mr.
In closing,
thank you.
Apple responds that it built the platform and should be able to decide what business model it uses. Well, the railroad companies built the railroads, the steel companies built the steel mills, the power companies built the power lines, the telephone companies built the telephone lines. They all made incredible inventions, but they all became monopolies, and that does not justify monopoly rents then, nor should it today. I thank you, Madam Chairman and members of the committee, and I'm happy to answer any questions you may have.
Thank you for your testimony. Any questions from the committee? I don't see any hands. Thank you, Mr. Buse, for your testimony and support. Our final witness today is Kyle Andier from Apple, who is opposed to this, in case you were wondering. Is Mr. Andier available?
Yes.
Thank you, Mr. Andier. Yes, the floor is yours. Thank you.
Madam Chairwoman, thank you, assembled members of the committee. My name is Kyle Andier. I'm here representing Apple as our Chief Compliance Officer, and I appreciate the opportunity to provide our perspective on this bill. And we have, and I'll keep the Chairwoman's admonition to keep this tight and bright. We do have significant concerns with this piece of legislation. I was listening with great interest to kind of the discussion around the earlier bills and the debates, and it really voiced some of the concerns that we share here at Apple in today's digital world, issues around security and privacy and how our children are transacting on digital products these days. And I would say, from Apple's perspective, we're very proud that we've managed to build the most secure mobile device in the marketplace today. And that's borne out in study after study. And it's a job that's never done. We have been working to secure this platform through our design of the hardware, software, and most importantly, through the review of the applications. So 12 years ago, we made the decision to open up the iPhone to third-party development. And we've seen millions of developers take advantage of that opportunity and the access and the tools and the technologies that we provide to them to create great apps. The quid pro quo is we want the ability to make sure that we can review those apps. And we review more than 100,000 apps each and every week, whether those are updates or for the first time. And we reject 40% of those apps. Why? Because those apps pose a threat to our users, to everyone who owns an iPhone. It could be that the application doesn't work. It could be that the application breaks your phone. It could be that it steals your data. It could be that it breaches your privacy. There are a whole host of reasons why we may be rejecting an app. And so our ability to control that is integral and core to making sure that we're making the most secure and safe device in the marketplace. I know the committee has heard a lot about our mobile payment system that we use on the App Store. And that, too, has very important implications for security and consumer protection. We have built in a very robust set of anti-fraud tools that managed to deter more than $1 billion worth of fraud in the last year. This is a significant benefit to both developers and to consumers, and something we're very proud of. I would say, as a parent of 4 young children, another feature that we're very proud of is the parental controls that we built to our payment system, particularly in the current environment where all of our kids are using their devices more than ever, whether it's playing games or learning at school. What we have done is build in a robust set of parental controls to make sure that your kid, as he's playing a game, isn't spending thousands and thousands of dollars on different items within that game.
Thank you.
Now, of course, unfortunately, there are always those incidents in which a parent may turn off their controls.
but we provide that ability and that opportunity for parents to make sure that they're playing that guardianship role over their children. We think that's incredibly important. It could be broken by some of the provisions in this bill. I think the third thing I would just kind of briefly mention here is, this model that we've developed for the App Store has worked over the last 12 years. We provided a new option for developers and consumers alike. In terms of developers, we provided them with tools, technologies, features to allow them to create just amazing iOS apps. And we did that at very low cost for the developer. So they pay a $99 a year program fee, and then if they decide to offer that application for free, we charge them nothing. And so in today's world, that means 85% of applications are available with no cost to the developer. So the developer can put that app up on the App Store and they're charged no commission. There's only a small subset of apps that pay a commission to Apple. And in Rhode Island, there are only two, as I think it was mentioned earlier, that pay the 30% commission. A handful pay a 15% commission. And the vast majority, nearly 380, pay no commission to Apple whatsoever. So we believe this has been an incredible benefit to consumers. It's been an incredible benefit to developers. And we're very concerned that this proposed legislation could break the model that has proven so successful for everyone in the marketplace to benefit a few successful billionaire developers.
Thank you. Thank you very much.
I have a question.
First of all, we have a question from Whip Chippendale, and then we'll go to Rep Lima. Whip.
Thank you, Madam Chair. Kyle, just a quick question. I had asked it earlier, and the person was unable to answer. I believe that there is a case in federal court right now that will answer the very question that this legislation seeks to address. Am I wrong, or is there such a case?
Representative Chippendale, thank you for the question. And you're right, there is a case that is scheduled to go to trial here in May that was brought by Epic Games, the backer of the Coalition of App Fairness. So they will be litigating that case in federal district court starting on May 2nd, and we expect a decision this summer.
It's nationwide.
Charlene, you gotta mute yourself.
Rep Lima, please mute your microphone.
Oh, sorry. Was he done? Okay.
Kyle, thank you very much.
Thank you. Go ahead, Rep Lima, since your microphone's unmuted.
Hi, Kyle, what I was trying to figure out here, maybe you can help me with this, because I'm concerned about the interstate commerce clause. So if this bill passed, would you have to change your platform outside of the Rhode Island borders, because then it would interfere with interstate commerce?
Representative Lima, thank you for the question. Absolutely. We operate a nationwide store today from the App Store perspective. We don't operate stores state by state. One of the great benefits of the App Store is it allows a developer to reach consumers in each and every state across this country. And so absolutely, it would have a significant interstate impact.
Thank you.
Thank you.
You're welcome. Yes, that is the antitrust issue and the legal quagmire and why there's a case pending up in May. So, there are any other questions? Yes, Rep Morales.
Chairwoman.
Yes, Rep Morales.
Thank you so much, Chairwoman. Kyle, can you please elaborate on the different thresholds for what app developers are to pay in terms of commission? Because you mentioned 30% with some companies in Rhode Island, then you mentioned 15% for others. And I just think 30% is significant, especially for a monopoly like Apple that is a multi-billion-dollar corporation. So I'm just trying to understand what distincts what app developers in terms of the compensation that they are to provide to you.
Sure. Thank you, Representative Morales. When we entered this market 12 years ago, we looked at what the prevailing rates were at the time. When you're looking at a game developer in particular, they are paying in excess of 40, 50% to console manufacturers like Microsoft, Xbox, or Sony PlayStation. We came in with a much lower price at the time, which is the 30% commission. And since we've launched the App Store, all we've done is provide new ways for developers to avoid paying the commission altogether or introduce new lower price tiers. So the most recent of which is the one we introduced last year, which is a small business program. So if you are a developer earning less than $1 million through the App Store, you're paying a 15% commission. What that means in practice is there's only a very small number of very successful developers who are paying a 30% commission.
Good question. Thank you, Rep Morales.
Thank you.
And thank you, Mr. Andir from Apple. Seeing no other questions from the committee, Okay, Rep. Tansey, quickly, go ahead, question.
Yeah, just a quick question, and I think you mostly answered it because I didn't quite catch the number, but I'm a lifelong Apple product consumer and have always felt that it was worth paying a little bit higher price for your hardware rather, and I'm wondering, should this bill pass, what that would mean for the safety of products that I would be interacting with on my phone. And I think you said something like 45% of the apps that apply you turn down because they don't meet the requirements that you have.
Mr. Ander?
Yes, Representative, that's correct. And sorry. That is correct. So we do reject a fair number of apps. What we're concerned about by this bill is it opens up the side door to the device and could create some real vulnerabilities and real issues, whether it's from a privacy, safety, or security perspective. It's like putting a side door in your house and giving the key away to everybody on the street. And that's a very real concern on our part, because our ability to ensure that we continue to live up to your expectations for security and privacy and everything else that we think our users value with our devices would be significantly compromised.
Thank you.
Thank you, ma'am.
Oh, you're welcome. Thank you. Wonderful questions, great conversation and discussion. I want to put into the record the following written testimony that we received, because that concludes our verbal testimony. Wayne Bro is opposed. Morgan Reed from the App Association opposed. Megan DiMuzio is in support. Max Belkey opposed. Lenny Lopes opposed. Lori White from the Providence Chamber is opposed. Kyle Andier from Apple, as you just heard, is opposed. Christopher Gilrine opposed. Carl Szabo from NetChoice is opposed. Bruce Gustafson is opposed, and the Rhode Island Business Coalition is opposed. This concludes the hearing on Bill 6055. It also concludes the hearing on the House Committee on Innovation, Internet, and Technology. May we have a motion to adjourn? Second. Thank you. I'm Rep. Deb Ruggiero on behalf of my colleagues in this committee. Thank you so much for listening this afternoon. Stay well, and we'll see you soon. Thank you.